Seated.
We will hear argument first this morning in Case 25-5146, Abouammo versus United States. Mr. Loss-Eaton.
Mr. Chief Justice, and may it please the Court, the question here is whether Mr. Abouammo committed his Section 1519 offense in San Francisco. In Section 1519, Congress created a broad document integrity offense, distinct from obstruction, that requires no communication, no obstructive effects, and no investigation. Under that broad law, Mr. Abouammo's offense started and ended in a 30-minute window during which he never left his home in Seattle. He was guilty, and his offense was complete the moment he finished creating the false invoice with the requisite intent. Whether he sent it to investigators, whether it affected them in some way, or whether an investigation even existed at all, none of that is relevant to liability under the statute. So the government didn't have to charge any of that in the indictment or prove any of it at trial. But the government now wants to have it both ways. It says the uncharged, unproven effect of Mr. Abouammo's offense means that he committed it in San Francisco. That is wrong. From the common law through the founding era and up through this Court's decisions in Balazs and Rodriguez-Moreno, venue has always turned on the location of the offense's essential conduct. That is the question that this Court's venue cases all ask, even if not always in so many words. Here, Section 1519 has one essential conduct element, falsification, and Mr. Abouammo did that entirely in Seattle. Sending the document to investigators may have been evidence of his intent, but it was not essential for conviction, so it cannot support venue. In arguing to the contrary, the government relies on general, out-of-context language from cases addressing very different offenses, and it all but ignores Johnson, Cabrales, and the ratification-era understanding of where similar offenses were committed. With no grounding in statutory elements or text, the government's rule is unclear and unworkable, and accepting that rule for the government's own convenience would swallow the test this Court has always applied. I welcome the Court's questions.
So are you saying that if he simply saved the draft to his computer, that the crime would have been complete?
Yes, exactly, Your Honor.
So how is that?
The crime is knowingly falsifying a document with the intent to impede an investigation. The moment he saved the document on his computer, he had done all three of those things. Even if he had never sent it to anyone, if he had thought better of it, if he had deleted it, at that point, all of the elements were satisfied and the offense was completed and it was over. And that is vital for purposes of venue because that's the scope of the inquiry that the Court applies. It asks, where did the defendant engage in the essential conduct elements of the offense, to use Rodriguez-Moreno's phrasing? In other words—
How do you prove intent?
If
he didn't send it and never intended to send it, you're defeating your own argument.
So if he hadn't sent it, then certainly the government would have a much harder time proving intent. But just as a matter of statutory text and elements, if he had created the document intending to send it to investigators with the hope of impeding the investigation, and then if he had thought better of it in that moment, say, and he thought, this was a terrible idea, what am I doing, and he had deleted the document, he would still have violated the statute and his offense would be over at that point. The text of this provision is clear as to this, and I don't take the government actually to dispute any of that, by the way. Congress knows how to write an obstruction statute that actually requires some sort of obstructive effect, some sort of nexus with the investigation or the proceeding, and Congress very deliberately didn't do that in Section 1519 because it wanted to capture a broader scope of conduct, responding to the Enron and Arthur Anderson document shredding and cooking the books. Congress said, we want to be sure that we're sweeping in conduct taken in contemplation of an investigation, even if one does not actually exist yet. And so to that extent, the government actually benefits from the statute's scope because it doesn't have to prove actual communication to investigators or obstructive effects. And those are therefore not elements of the statute that are required for conviction.
Counsel, can I ask you a question?
Is there any other — it just seems very bizarre to me. Is there any other body or statutes that are like that? I mean, the guy does whatever it is to create the document, and he says, oh, that's a crazy idea, and tears it up. You're going to prosecute him?
So practically speaking, of course, it would be relatively difficult for the government to learn about that in the first place. But I think the specific scenario that Congress had in mind when it wrote the statute is illuminating, and that is the Enron scandal. And there, not only were Enron and Arthur Andersen shredding documents, which of course doesn't involve any communication with anybody by definition, but they also were keeping a second set of records, not because they had any specific intention of investigators ever seeing them. I'm quite sure they hoped that that was never going to happen, but essentially it was just in case. And so Congress quite deliberately severed the nexus between an actual proceeding, because the statute doesn't even require that there be an investigation or proceeding, and the conduct.
Well, but I mean, that's a huge conspiracy, affecting all sorts of different people and operations. You're suggesting the same rule would apply in the case that I gave. Somebody who, drafts up a falsification, thinks better of it, tears it up. How much time is he facing for that?
I don't remember offhand what the maximum is, Your Honor. But just as a matter of statutory elements, that's what the text says. And again,
Have courts actually applied it in that way?
I don't know.
If you look around the universe of 1519 prosecutions, what are the, what might be considered the fringe cases?
I don't know offhand of a case in which a court has ever considered a scenario where someone just created a document with the intent of impeding the investigation and then never did anything further than that, presumably because, practically speaking, it's going to be quite difficult for the government to find out about that. But just, again, if you just turn back to the text, knowingly falsifies a document with the intent to impede. Those are the three elements. That's all you have to do. And that is what Mr. Abouammo did.
If that's, let's just imagine that it did require, just work with me here. Let's assume that it did require some kind of communication. The agents were in his house, right? They were downstairs. Let's imagine instead of emailing it, he handed it to them. You would still say that all the offense conduct happened in his home in Washington.
Absolutely, yes.
Okay. How does it change matters? Again, just assuming that some kind of communication of the document is required, that he emailed it to them, so he could just say, for convenience, I'm just going to go ahead and email you the document as an attachment rather than physically handing it over. In your view, would that change, how might that change matters, if at all?
I don't know that those scenarios are any different, assuming that there is some sort of communicative element in the statute. Handing the piece of paper to someone versus emailing it to them, I think, is communicating to the same extent. And so in either of those cases—
So we don't have to worry anything about a server. This is, it's going to their San Francisco server and their computer there and living on it in some way, right?
No, you do not have to worry about that, both because as a legal matter, the conduct would be the same, and also because there is no evidence in the record about where the government's servers actually are or were.
Okay,
the government, I think, is hoping that you'll assume that the servers are in San Francisco, but that was never asserted at trial. There's no evidence of it.
Okay, so you don't understand, and obviously we can ask Mr. Yang this when he stands up, but you don't understand the government to be contesting your interpretation of the statute and that only the creation of the document is required even if you put it in the drawer and never communicate it to anyone.
I do not understand the government to contest that, no.
And is that because, and I'll ask the government this, but is that because both of you are focused on the statutory elements, not so much what the facts were in this particular case about how he transmitted the document, but what the statute requires, and that's what we should be focused on in determining venue?
That is exactly right, Your Honor. This Court's venue cases have always asked, where did you commit the elements of the statutory offense necessary for guilt? In other words, where did you commit the actus reus of the offense?
So these questions about, boy, that's a weird offense and a strange actus reus really, it seems to me, isn't dispositive of our consideration here. We have to look at the statute and determine what its actus reus is. And so you say it is falsifying a record.
Yes.
With the intention that it impede an investigation.
Yes.
But both of those things, the falsifying the record and presumably the intention, occurred in Seattle in this case. And so that's why I think you're saying Seattle is the appropriate venue.
That is exactly right, Your Honor. And cases like Cabrales are a perfect illustration of this. In Cabrales, the court emphasized that we're not asking in a broad sense, what did you do in a sort of related factual way? We're looking at the specific statutory proscription that Congress enacted, and then we're asking how did the defendant violate it and where did they do so? So in Cabrales, it was irrelevant to venue that she also had engaged in a drug distribution conspiracy in Missouri for which she was also going to be prosecuted no matter what, and that she had been physically present in Missouri for various parts of that scheme, or even that she had to know for the substantive money laundering counts that the money was the proceeds of a specific other offense, which was the criminal conspiracy in Missouri. The court asked simply, where did she actually commit the acts that constitute the money laundering offense?
The acts or the elements? Or is it all elements or is it some subset of elements?
So the way the court has framed it is essential conduct elements, which I take essentially to mean the actus reus. None of the court's cases seem to treat intent as part of the venue analysis for these purposes. But I don't know that that would make a difference, even if you looked at the intent element, as Justice Jackson said.
Do you think that there's a reason to treat those two things differently?
I think historically, commission has been about acts. If you go all the way back to the common law cases or the ratification era cases, the court is generally looking at acts or actions, conduct, in the sense of the actus reus. And I don't know of any example that does look to an intent element. But even if you do, I don't think it changes anything here, because if the intent element was committed anywhere, it was committed where he was. It was committed in Seattle.
Counsel, we have the government's late-breaking argument that there's a separate metadata document that was created in San Francisco. I know you argue that that's forfeited. I wonder whether you would actually be better off having the court address that, though, because one can imagine that we say it's forfeited in this case, while in every 1519 case to follow, the government's going to say, oh, we have a separate new document with different metadata in our offices, and that changes everything. So we'll be right back here. Thoughts?
So forfeiture aside, Your Honor, I think that argument has got real problems, both legally and factually. Factually, you don't just have to create or falsify a document to commit the actus reus. You have to do so knowingly. And there is absolutely no evidence in the record here at all that Mr. Abouammo knowingly created a copy of a document anywhere, much less in San Francisco, because as Justice Barrett and I were discussing, there's no evidence about where the server even was. But if you get past all of that, then you get to the legal question. I'm not aware of any support for the government's position that just emailing a copy of an existing false record to someone is a separate act of falsification that can violate the statute. The best analog that we've found is the Sixth Circuit case that's cited in our reply, which says that at least for Section 1001 purposes, faxing and mailing 2 copies of a false statement are not 2 separate violations because there's no additional falsehoods or false content. And I think that's consistent with the ordinary meaning of falsifies, which means essentially to make deceptive. It's the act of introducing falsity.
He falsified the original. The duplicates are duplicates. He didn't falsify anything in the duplicates.
Exactly.
If there's any falsification in the duplicate, it might be the government's metadata.
Yes, I think that's fair, Your Honor. And this is not to say, by the way, that he couldn't potentially violate some other statute by actually communicating the document.
Oh, goodness, I'm sure there are many out there.
I think there probably are. But for purposes of Section 1519, the only act of falsification was the creation of this document on his own computer in his own home. And that was the government's consistent position at trial in its opening arguments, in the Rule 29 argument. The government quite consistently said that the falsification was when he went upstairs and he modified the PDF on his computer, and at that point, the offense was over.
What if situation? Go ahead. The situation in which someone creates a false document, but then never sends it, changes his mind, that person is going to be prosecuted under this statute. That's really fanciful. What is going to happen in the real world is that the person creates the document, and then sends it. But your argument is that even if this had been emailed to San Francisco, emailed to a specific address of a person in San Francisco, there would be no crime.
That is correct, Your Honor. And I think Johnson is the perfect illustration of why that is. In Johnson, the offense required using the mails for the purpose of sending or bringing into any state contraband. So there was similarly an intent requirement, much like there is here. It was even more closely tied to the interstate communication. And the court said, that does not change the venue analysis. We construe that statute to proscribe only the act of sending, meaning depositing in the mail. And once you've done that, the offense is complete. And so we don't care, really, that you did that for the purpose of sending something into another state, or even that you actually succeeded in doing so, thereby causing precisely the effect that Congress enacted the statute to prescribe.
What about Lamar versus United States, where the court held that venue was proper in New York for a defendant who intended to defraud people located in the state, and the court held that venue was proper there even though none of the defendant's conduct necessarily occurred in New York, and even though the charged offense did not require him to cause any fraud in New York. That seems like pretty much the same case as this one.
I don't think so, Your Honor, because Lamar is, just like all of the cases that it was applying, conduct-based. The court, in a single sentence, says he might even have been in the Southern District, but assuming that he wasn't, when he made phone calls pretending to be a congressman, his impersonation, and this admittedly is a phrase that I know the government likes from Lamar, took effect in the Southern District of New York. And then Lamar cites Burton. And Burton very carefully conducts a conduct-based analysis to ask where the agreement, the illegal agreement there, was formed, relying on cases like Palliser and armor packing. So I think for Lamar to support the government here, it would have to be doing something completely different from all of the cases that came before or after it.
The court did not know where he placed the phone call from. So let's assume he placed the phone call from Washington. From Washington, he calls somebody in New York and impersonates a government official. And the court says, and the statute makes it a crime to intend to impersonate a government official. What's the difference between that situation and here, except for the fact that the technology changed?
The difference is that there was not only a requirement to act intentionally to try to defraud someone there. The statute, as this court had just construed it a few months earlier, required some improper assertion of authority, almost a sort of overt act to actually manifest the impersonation. I know the government says that you could commit the actus reus by standing in front of your mirror in your bedroom, but this court had held that's not correct, that's not enough. You had to actually do something assertive, and the assertion there was the phone call. And the phone call, under cases like Palliser, happens on both ends. It happens where you physically are, and it happens where the person you're talking to is. And in that case, the person you were talking to was in New York. And so—
Okay, I get your point. At what point in time do you think the intent that is required by 1519 has to occur?
It certainly has to exist when you are falsifying the document. I think you have to have all three elements together, the knowingly, the falsification, and then the intent. So
you can't withdraw from this offense for 1/2 a second. Someone creates a false document, but never says, I'm going to just create this, but I'm not actually going to send it. And then for 1 second, he's tempted. I'll actually send this. And then he immediately says, no, that's the wrong thing to do. Too late?
I think there you would not have an offense because you wouldn't have had the falsification with the intent to impede, which is what the statute requires to coincide. Now, admittedly, these are all pretty, I think, strange.
Seriously? So he creates the false document, not intending ever to send it. So his intent at that time is not to do anything, not to send the thing. But later, he changes his mind, and he says, now, I'm actually going to send it. There's no offense there because he didn't have the intent to deceive at the time when he created the document?
I think that's right, Your Honor. I mean, it's an unusual scenario, and I have a hard time imagining how it might ever come up. but the statute says you have to act knowingly and you have to have the intent when you falsify the document. I'm not aware of any cases where the court has said that a later manifestation of intent that didn't exist when the actus reus was committed could satisfy a crime. But ultimately, though, even if you disagree with me about that scenario, I don't think it makes any difference here because Mr. Abouammo undisputedly had all three elements at the same time when he created the document on his computer, and at that point, the offense was complete. And again, I don't take the government to actually dispute that. And so that makes this case just like Johnson or just like Cabrales or any number of other precedents where the court has looked narrowly at the essential conduct, the actus reus. Where did you do the thing that Congress proscribed? And the thing that Congress proscribed here was the falsification, which Mr. Abouammo did entirely in Seattle.
And if the statute did require some kind of interference or obstruction, that would have happened in California. Is that correct? In San Francisco?
I don't know if there's enough in the record to establish that conclusively, but it's certainly plausible.
Okay. And if you had an intent to have that happen in San Francisco, this, I guess, goes back to the question of whether a mens rea element counts. But if you have the intent that the interference happen in San Francisco, that is enough or that's not enough?
Intent alone, where the statute does not actually require an effect, is not enough, because that is the statute that we have here. And that's
because
Johnson.
The intent is always where you are, as opposed to I have an intent to make something happen in another place?
Because the intent is where you are and it's not conduct. And as I said, the court has always focused on conduct elements. But again, even if you want to look more broadly at elements, all of the elements were committed in Seattle.
So you think Congress could, you just told Justice Kagan, intent unless intent to cause an effect, so you think Congress could say that venue lies someplace where you wanted there to be an effect flowing from your conduct, just as a matter of intent?
If the effect is required for conviction, then yes.
Don't you have to show that here?
No. You just have to show that the
intent, you have to, there are two different mens reas in the statute, right? There's the knowingly altering, et cetera, falsifying, and then with the intent to impede, obstruct, or influence the investigation or proper administration of any matter. On that latter one, don't you have to show the intent to impede, obstruct, or influence?
Yes, you do.
Which means an effect, intent to cause an effect, I think.
Yes, what I'm saying is that Congress could create venue there in the place of the proceeding if the effect itself were required for conviction. Not just the intent to cause it, but actually causing it. And that is
Why
really—
is that? Why are you making that distinction?
Because in that situation, at least sometimes, the causing the effect is part of the actus reus that actually then satisfies the essential conduct elements.
So if you keep going.
Go ahead.
I do think, honestly, probably the hardest question in this entire area, which this case does not implicate, is there a distinction between a statute that requires an effect for conviction, but seemingly as a standalone element, and then a statute that actually describes the actus reus in terms of causing an effect? But here, we're not in either of those scenarios because an effect of any kind is not required for conviction, so the court does not have to get into that. My point is simply that there are some situations, certainly, where Congress could create venue quite properly for an obstruction-type offense to the extent that an effect, an obstructive effect or an impeding effect, is actually required for conviction, such that it is part of the elements of the offense.
So the intent to cause an effect elsewhere is not enough to get venue elsewhere. So, mailing a bomb elsewhere, and the statute's written in terms of you put it in the mail with the intent to kill someone elsewhere, and that's all the statute is about. The elsewhere is not good enough.
So I'm assuming in the hypo the bomb doesn't go off.
Correct.
So I think then it would depend on the specifics of the statute itself, because—
I don't think so under your theory. I think there's no venue in the other jurisdiction.
So the reason I say that is that cases like, if you line up Travis, armor packing, and Johnson, you've got all three of those cases involve sending something from state to state, either in the mails or by shipping. And in one case, the court says venue only at origin. In another, it says only at destination. And in the third, it says anywhere along the way. And I think what that tells us really is you have to look very carefully at precisely the conduct that Congress prescribed. So I think it would be a little hard to answer that question without actually having the text in front of me. I think it's plausible that that statute could be written in a way that does actually reach past just where the person physically acted.
Thank you, counsel. Justice Thomas, anything further? Justice Alito?
There's a peculiarity about this case because the FBI investigation resulted in several other convictions, and you don't dispute venue for any of them, any of those others. You dispute venue only for his attempt to obstruct the investigation. So if venue is okay for the other charges, why doesn't it suffice for the charge that's at issue here? In other words, does the venue clause require him to face two trials and two venues for charges stemming from the same investigation? Have we ever held that?
I don't know that this court has ever squarely held that, but the Sixth Amendment on its face says that trial shall be held where the crime singular is committed. And I understand the courts always to have read that, as it suggests, to mean that venue must be done on a count-by-count basis. Now, it doesn't necessarily mean that Mr. Abouammo has to be subjected to two trials. Of course, venue is waivable. That's his right. But it does mean that absent a waiver on his part, each individual count has to be tried where it was committed. And I will note that does not distinguish this case at all from Cabrales. Everything that you could say about why a trial in this case just makes sense in San Francisco could have been said in Cabrales as well, including other charges that were going to be tried there no matter what.
Thank you. Justice Sotomayor?
So Congress did in 1512C require the government to prove that a federal investigation was impeded because of the defendant's conduct, correct? And it enacted a venue provision based on those effects, right?
Yes.
And so those statutes exist. We have said the same thing, that Congress is free to look at effects, but we're not, meaning absent a congressional statute that permits venue in places other than where conduct is committed, we can't do it, correct?
So I think the right way to think about what Congress can do with a venue statute is that it can make sure that venue lies anywhere that an offense could be said to be committed within the meaning of the Constitution, but of course it can't go beyond that. And so certainly there are ways to violate 1512 or 1503 that involve actual effects, and in those situations venue would be proper either where the person physically acted or where the proceeding.
And that's what they do.
Yes.
Now, with respect to Lamar, one of the elements of the Lamar charge was an overt act that that required the use of a communication between people in the impersonation, correct?
Yes, some improper assertion of authority, which I think has to be communicative in some way.
I think the statute used the word communicative. And so when the court in Lamar talked about the person in New York probably being the more proper venue because the communication happened in New York, correct?
I think Lamar is basically just Palliser with a telephone call instead of a letter, yes.
Exactly.
Justice King? Justice Gorsuch? Justice Kavanaugh?
How are we to think about 1512I in this case?
So on our view, and this is actually something that we have in common with the government, because the government has this problem too, Section 1512I is unconstitutional in some applications. On our view, it is unconstitutional where it is applied to prongs of the statute where an effect is not required. And on the government's view, it's unconstitutional whenever an effect is not actually intended and manifested. So there's some daylight there, but I think actually not a huge amount. And so, yes, that does mean that in some cases 1512I cannot be applied as it is written.
What if he was interviewed in Canada, in Vancouver?
So under the Constitution, Congress has plenary authority to decide venue for offenses that are cognizable under U.S. law but that are committed outside of the United States, and it has in fact done so. So I think there it might depend on, say, where he had been apprehended or brought into the country, but certainly there would be a place to have venue in the U.S. for that action.
Constitutionally, but not under this scenario, this statute?
Not under 1512I, but there are other venue provisions.
I'm back to 1519 now.
So if he had done the same thing in Canada rather than in the U.S.
Mm-hmm.
So that, I mean, that I think there would be an extraterritorial jurisdiction question, which would implicate a different
under
set of
your
issues.
theory, I just don't think he could be prosecuted under 1519 if the interview had been in Vancouver rather than Seattle, right?
If the offense were prosecutable at all, I think venue would not be an obstacle because it would be allowed under the provisions that govern where someone commits an offense outside of the United States.
Okay. Thank you.
Justice Barrett? Justice Jackson?
So would you encourage us to be thinking about this in terms of identifying this offense as not a continuing offense? Is that how we're supposed to? I'm just trying to sort out the cases that seem to suggest that there are circumstances in which a crime that is similar to this could be charged in different locations. And you've suggested that those cases are distinguishable on the basis of this continuing offense idea. And I haven't heard you mention that specifically in today's presentation, so I'm just trying to figure out where that fits.
Yes. So I think armor packing tells us essentially how the continuing offense doctrine works in this context, and that is that where the essential offense conduct, so essentially the actus reus, continues or extends from one place to another, then venue is proper in each of those places. But where the actus reus is committed only in one place, venue is proper only there. So I don't deny that it is possible to violate Section 1519 in a way that would create venue in more than one state. If he had started creating the document in Oregon and then finished it in Washington, probably he could be charged for either of those. But here, all of the actus reus, the falsification, happened in one place. And that is what distinguishes cases like Palliser, Lamar, and armor packing, because in each of those cases, the actus reus, whether it was offering the bribe, or if it was impersonating a federal official, or it was the illicit transportation, extended across state lines from one place to another.
And you say even Lamar, I mean, demanding or obtaining is in the statute.
Yes, so Lamar was charged, there are two prongs to that statute,
Yes.
one of which doesn't specifically require the demanding or obtaining.
Right.
But this court had construed that first prong to require some sort of improper assertion of authority, and there it was the telephone call, was the improper assertion of authority.
Thank you.
Thank you, counsel.
Thank you.
Mr. Yang?
Mr. Chief Justice, and may it please the Court. Petitioner knowingly falsified an invoice with the specific intent to obstruct an FBI investigation he knew was occurring in the Northern District of California. He then manifested that intent, manifested his obstructive intent, and affected the investigation by transmitting the document to the FBI by email. That conduct, directed at and having a direct effect in the Northern District of California, makes the district a locus of his crime. The Constitution's requirement that venue be where the crime was committed looks beyond the physical location of the defendant and turns on the nature of the crime itself. And our position focuses on the special nature of a Section 1519 offense. It is an inchoate offense that, like conspiracy, is merely a step towards the commission of another crime. The offense has a special type of statutory intent element, not just mens rea, but specific intent to commit another crime, here the obstruction. That necessarily contemplates, the defendant must contemplate that more must be done to achieve the objective that is required as part of the crime. The conduct that continues to manifest that intent by furthering that objective is part of the crime itself. And where that conduct is intended to produce and directly produces a detrimental effect in that district, the district is proper for venue. Petitioner's conduct manifesting his intent, here his transmission of the falsified record, is akin to an overt act in furtherance of a traditional conspiracy. That provides a basis for venue. Neither are conduct elements of the offense. Both occur after all the conduct elements are completed, and both are taken to further the intent element objective of the crime. That is the ultimate commission of this other offense. Petitioner's view that venue is proper only when an essential conduct element occurs cannot be squared with the settled rule that venue is proper for conspiracy in any district where any overt act occurs, even though the overt act is not an offense element. The same venue rule applies here.
Well, Mr. Yang, this is not conspiracy. So is there anything that is done by Petitioner in California? He drafted the invoice in Seattle, and he transmitted the invoice from Seattle. Now there's nothing left but the receipt by the FBI.
Yeah, we don't dispute that his conduct and the offense itself was completed and could have been prosecuted before he hit the email. We're not disputing that. Our point is somewhat different, which is even though when an offense elements have been all satisfied, there's conduct that can still occur that is furthering the specific intent to commit the other crime.
What is that precisely?
Well, that was the emailing.
But he emailed it, he transmitted it from Seattle.
Mm-hmm. But it was directed specifically at the Northern District of California. He knew the agents were conducting an investigation there, and that is where they're from. It's no different than pointing a gun and shooting. He shot the email, and he hit Northern California. And so, but the main point, I think, is that offenses, the relevant offense conduct, where the crime is committed, can encompass things that happen after the crime can be fully prosecuted. And that's true both with conspiracy and with respect to intent, both inchoate crimes that share an essential feature with this crime, which is there has to be specific intent to commit another crime, such that the inchoate crime is a step towards that further crime.
Mr. Yang, I gather it's common ground between the parties that the vicinage clause was added because of Parliament's decision to allow the transport of colonists back to England to be tried there. So under your interpretation, that would still be allowed, right?
No.
The Boston Tea Party takes place entirely in Boston, but it causes effects back in England. And so why can't you say it's all right to take them to England?
I don't think that that's quite right. We're not saying that any kind of incidental effects or kind of dignitary effects that might affect the government would cover. If that were true, any offense against the United States could be tried in D.C. where this is
the whole point of treason, I'm sorry,
no, go ahead.
Is aimed at the king, right? I mean it wasn't incidental, I think is what the chief is. Let's hypothesize.
Could I just, the aim at the king is a slightly different thing.
If you might, let's work with my hypothetical. We have a crime whose intended effect is the king in England, okay? That's certainly how the framers thought of it themselves when they were in the Revolution. They were aiming at Parliament and the king, and they wanted to depart from them. And the Crown did want to try them in England. And that was considered an infamy that led to the Sixth Amendment. And I do want to answer the Chief's question, assuming hypothetically that the founders were aiming at the king and Parliament, and that was their intended effect. Could they have been tried in England under your theory?
No. The offense needs, our theory turns on a specific feature of this type of crime, which is that you have to specifically intend as an element of the offense to commit another crime elsewhere. You know, here's the crime of obstruction. Now,
so
aiming
if it were an inchoate offense in America then, okay, a conspiracy offense, an inchoate offense, then they could have been tried in England.
No, this is
I think,
no. I want to just take a step back. They rely on Blackstone. Blackstone explains there are 7 types of branches of conspiracy. The relevant branch for the colonists would have been taking up arms or waging war, right? The element that they talk about is the first branch of conspiracy. That is where you actually act with the purpose or design to kill the king, literally kill the king. That is a different type of offense. And if you have the overt acts, let's you say you actually bring, supply arms, or your people go to strike the king, even if you were in the United States and they struck the king in England, yes, I think you would, as a co-conspirator, as part of that, would be able to go there. But that's not what the colonists were upset about. The colonists were upset about actions taken here that have direct effect here, that the only connection was some kind of vague dignitary offense of treason. That's different.
Oh, I don't think that's how King George took it. I mean, saying the Boston Tea Party was concerned with effects here, and I mean, it was intended to send a very specific message to London that we don't want are citizens picked up and taken away. And then they enact a clause in response to that would prevent precisely that from happening.
Well, I'm not talking about what might have been in the mind of the king. I'm talking about what the law required. And what the law required was there were different types of treason with different elements. And what they're talking about striking the king literally meant killing the king. That was the offense. It was like attempted murder on the king. Look at Blackstone. It spells out the 7 branches. They're relying on something different here to conflate the idea of what we have, which is based on the idea that inchoate crimes like conspiracy or attempt can continue beyond the point at which the crime can be prosecuted.
Mr. Yang, isn't really the point of the Chief and Justice Gorsuch's questioning that this clause, the law, the way in which the Constitution developed around this issue was a concern that people were being removed from the area in which they had committed the essential elements of the crime and taken back to England. The government was, or the Crown was gaining or thought they would gain an advantage by trying them back there rather than here in the colonies and then later here in the United States. And so the concern, I think, with your theory is that because the government controls the location of the investigation, you would end up with the same kind of troubling dynamic, that the essential elements of the crime you admit in terms of the actus reus is happening in one location. But to the extent that the person intends to affect an investigation of the United States says, well, our investigation was happening in San Francisco or New York or wherever.
The investigation preceded his crime.
But you
like it already had to
that.
exist.
But what I'm suggesting is that you control that. So here's the hypothetical. Suppose that in this very same situation, the United States had decided that 1519 crimes are best prosecuted by the Southern District of New York because they have the most experience, because they think they do better, those prosecutors. But the underlying issue, all of the alleged foreign interference and espionage and whatnot that Mr. Abouammo was allegedly engaged in, happened in San Francisco. And the United States sends New York-based agents to his home in Seattle because they're the ones that are doing the investigation, and the same set of facts ensues. Is your view that venue would be proper in the Southern District of New York?
If the agents were, instead of being in San Francisco, they were in New York.
Yes. They're from New York, the Southern District of New York.
And he knew they were from New York, and he still transmitted it to New York. Our position would be...
But transmission is not in the statute as a statutory element, right? The statute that I'm positing is the same, that all he has to do is falsify the document and intend to do so, the falsification, where he is.
Our position is that his relevant conduct for purposes of determining where venue is appropriate continues beyond the completion of the crime, just as...
There's no continuation here. It's just the New York agents in his living room. And you're saying, I just want to be clear, you're saying the United States could try this person in New York because the investigating agents are from New York, even though all relevant conduct in terms of the statute occurs in Seattle.
Yes, because he intended to and specifically did affect the investigation in New York.
And Mr. Yang, that doesn't matter. Let's see, how important is this continuing intent to your argument? Are you saying that, let's imagine he didn't email it. He just creates it in his house and that's it. You've said that that would violate the statute, right? Okay.
It would. I mean, as a practical matter, we might not be able to ever prosecute it.
Well, right, but you're
yes,
saying it would.
It would violate the statute.
So tell me how your venue theory works there.
It wouldn't work there. You always have venue where there's an actus reus, right? We know that.
Sure.
So you could prosecute it in Seattle. The question is whether you could also prosecute it elsewhere. Crimes aren't always committed in one place.
But doesn't he intend when he, okay, so the agents show up at his house, he knows they're investigating in the Northern District of California, so when he falsifies the document and he's intending to obstruct the investigation, he knows where it's going on. It's just that he puts it in his drawer. Why would your theory be any different?
Our theory relies not only on the intent. We're borrowing from Ford's explanation of the court's venue cases, right, including Lamar. Ford explains that when acts are done outside a jurisdiction but are intended to and do have a detrimental effect.
And do.
And do have
But the
produced
statute doesn't require that.
well,
right?
none of this is part of the statutory elements.
Okay.
Our position, we are accepting that the elements of the offense were satisfied upon falsification. He made it on his computer. We could have prosecuted if we knew about it. We would never know about it. But yes.
Yeah.
Our position is that further action that furthers the intent, that seeks to have that intent fulfilled. Remember, the intent is actually to obstruct. You cannot just falsify a document and obstruct.
So, Mr. Yang, if I understand you correctly, you're saying that Mr. Loss-Eaton is just using the wrong test. If he tells us, look to essential conduct elements, you're saying, you agree if you look to essential conduct elements, he wins. You shouldn't look to essential conduct elements. And then you're also saying it's not enough to look to just the intent of the person, because the intent of the person, I mean, tell me if I'm wrong about this, but is that, why don't you tell me that first?
I think that's right, but remember, ultimately—
You think it's right that that's not enough either?
I'm sorry, but I just wanted to say this—
The person has an intent to obstruct an investigation. That still is not going to get you venue where you want venue.
That's not our theory, yes.
So what is going to get you venue where you want venue?
So—
Because now we're looking outside the statute itself.
I don't think so. You're understanding what the nature of the crime is. Ultimately—
Well, the nature of the crime, I mean, the nature of the crime we usually think is like what the crime requires the government to show. It's the elements of the crime.
Let me give you two examples.
We can have a conversation about whether the elements include only conduct elements or also include mens rea, but you're trying to get us to look to the statute and devise a crime that doesn't appear in the statute and then say, oh, if you think about that crime, we'll have venue in California.
Let me give you two examples, and they're both in the inchoate context, because I think that's important. The inchoate, remember, inchoate crimes, what we're talking about, are crimes where you have, as an element, the intent to commit another crime. And you know the crime is not, your inchoate crime is not sufficient. More needs to be done because you haven't completed the crime. That's the premise. There are two other examples. Conspiracy. Traditionally, the actus reus is the agreement. That's it. The intent is reflected in the agreement to commit another crime. As soon as you form that agreement, right then, you can be prosecuted.
Well, that's because conspiracy, Mr. Yang, though, is we impute the actions of your agents to you, and this isn't a conspiracy statute. So let's—
Well, that's different. That's actually a different—
Mr. Yang, please.
I would just try to—
Mr. Yang, thank you. If you would answer Justice Kagan's question without respect to conspiracy and limit yourself to inchoate offenses, that would be helpful to me, and I think probably to her, and maybe even to your client.
Well, inchoate offenses, including conspiracy, they also include attempt. Let me give you an attempt example. In Resendez-Ponce, the court recognized that you can have multiple substantial steps. What you need for the elements of an attempt crime are intent to commit the other crime and a substantial step towards it, right? So in Resendez-Ponce, the court recognized there can be multiple serial substantial steps. At the first substantial step, the crime can be completed, right? I mean, prosecuted. You have a substantial step, you have intent. But it continues. Why? Because the idea of the crime is you're trying to do something more than just the attempt. You're trying to complete the other crime. So if you take another substantial step, that is also going to be a basis for venue, even though you could have already prosecuted. It's because the idea of the crime is you're trying to commit another completed crime. If you make an agreement with others, it's the same thing. You could be prosecuted as soon as the agreement. No actions over actions traditionally defined as conspiracy have to occur. But if they do occur, if you try to manifest your intent, further your intent to achieve your objective, they're still considered part of the crime, even though they're not offense elements. That's the whole point, both for attempt and for agreements. You have the same thing. We say it's the same thing here, where there's an inchoate crime with intent to commit obstruction of justice.
Can I ask a clarifying? Go ahead. Go ahead.
Justice Alito?
All right.
And we start focusing on intent we're still focused on elements, but we're just focusing on how the statutory intent element, which is special, not just mens rea, but like intent to commit another crime, something specific, how that gets manifested as part of the crime.
Right. I just want to try to put this in perspective. So this is an unusual statute, and it was enacted in response to Enron, is that right?
It was.
And was it part, I can't recall this precisely, was it part of the same act that included the statute that we had in Yates?
It is the same statute.
Right.
Oh, sorry, it's in the same, yes.
Yeah, right, with the fish and the tangible objects.
Yep.
So
Yep.
it was enacted under circumstances where there was a kind of a panic about Enron, and maybe Congress didn't draft things as precisely as it should. So, I mean, you're trying to defend this particular conviction, and I understand that, but maybe when you're told that what you're doing is a violation of the Declaration of Independence, you might think about what seems to me the more important point for lasting significance is the situation where there's an intent to commit a fraud and the transmission of the document that would carry out the fraud. That seems to me to be the important point. And to say that in that situation there would not be venue in the place where to which the document was transmitted would be of quite a bit of importance. So maybe you could talk about that.
I think that's really not that different from what we're saying here, because when you have the statutory intent component that you have to commit another crime, the whole nature of the crime is a step towards, an effort towards completing the other crime. So things that complete the crime, things that complete the obstruction, like the transmission, when it's directed at a specific place, it actually has an effect there, is properly considered part of the crime for purposes of venue. That is our position. And it's a little bit shocking that you can have this specific intent as an element that we proved. No doubt, he's intending to obstruct this investigation in the Northern District of California. And he shoots off his email, just like shooting a gun at Northern District of California, to achieve that objective. And venue is not proper in the Northern District of California. It's a surprising result.
Mr. Yang, how do you account for Cabrales if you're right? Why doesn't that case come out differently?
Yeah, thank you. Cabrales this is over 2 pages of the opinion, they emphasize the money laundering there is committed after the fact of the early drug crime. It's a backwards looking. We have a forward look.
But wasn't the government's argument in that case that it was related? Whether it was after it temporally, they connected. I mean, this is why the government said we can do this in Missouri because the money laundering that she engaged in Florida is connected to.
And Cabrales says the test is not related, but Cabrales does not say, here we have a different offense. There the relationship was backwards. It was completed by others in Missouri. There was a money laundering offense that was not looking back. It was, it was after the fact related to it.
So, Mr. Yang, how do
Florida.
you deal, let's do it with a forward-looking one. How do you distinguish Johnson? There, the crime, I never knew there was a Federal Denture Act.
Yes, there was.
Okay, which made it illegal, quote, to use the mail to fabricate a document for the purpose of sending or bringing it into another state. Any denture prepared by the person not licensed to practice dentistry in the state into which the denture is sent. And we said, in that case, that purpose or intent to do an act is not measured by the final destination where the dentures were received, which, by the way, is the only place where the illegality could have happened, but that only sending the item from Chicago qualified as venue. Seems that that statute is completely comparable to this one and talks directly about intent not being adequate to house venue.
We think Johnson is different in an important way. The nature of the offense was understood to be simply placing it in the mail with the idea that it's going to go forward. But nothing further had to be done.
You told me that the nature of this offense is the creation of the document with the intent in Chicago. If he had never mailed it, he would still be guilty.
No, it's slightly different.
That's what you told Justice Kagan.
The offense here, it's not just any kind of mens rea. It is intent, it's a specific intent to commit a further crime. There are more things that have to happen for that further crime to happen. It has to be it has to come to the investigation to obstruct the investigation. In Johnson, the court
you don't have to prove obstruction. You didn't have to prove
that is
anything
true.
about the other state. Well, you did have to prove
that's
that
why
it was
we
illegal.
That's why our position is that the actual conduct, but conduct that is manifesting the express intent element to commit another crime by trying to commit the other crime is part of this offense. That is different from Johnson, because in Johnson, the court construed it as simply placing the thing in the mail and you're done. That's not the case.
But here
within the
you
code
just
offense.
make the document and you're done. And if I understood you, I just want to be clear that I understood when we were talking before and when you were talking to Justice Kagan, that you're conceding that venue would not lie if he had the intent to obstruct the investigation in San Francisco and created the document, harboring that intent, and put it in his drawer. You said, I think, correct me if I'm wrong, that venue would not lie in California.
But the difference is when you do have additional conduct, which is manifesting the intent in order to achieve that further crime, the obstruction, which you need to, because you can't just...
I guess I just want to know why. If your theory, I thought your theory was about where you intended the effects to occur. So why isn't venue sufficient in California if he just put it in his drawer?
Our theory is that you not only have to intend it, but you actually have to, your action has to produce it.
So your action has to actually produce the effect?
Produce the obstruction or something close to it.
Presumably he could have been prosecuted under an obstruction of justice statute then.
Well, he could have, as well as under the intent.
Would it have been different under your theory if he had airdropped the document to the FBI agents as opposed to emailing it? Because then it would have all happened.
I don't use AirDrop, but I think that's an Apple product that like you upload it somewhere.
Yeah, are you an Android guy?
I'm an Android guy. I'm sorry. I'm really sorry. I was an old engineer.
It just means that you send the document and it's not emailed. It's just kind of goes over the home internet.
Yeah, it shouldn't matter. It's the ultimate destination that you're intending to get to is what matters. The fact that it might be on a server somewhere, what you're trying to do is send it to the FBI agent that you know is investigating in Northern District of California from Northern District of California.
You have to know that the investigation is taking place in that district. Suppose you just know that there's an investigation someplace out there that is taking place. You intend to obstruct it.
Yeah.
You intend to cause these effects wherever this investigation is occurring. What then?
Our theory is that a crime has committed under 1519. There is a crime, but our theory of venue would not apply. So the only venue you would be able to prosecute there is where the actus reus is.
And where is that in the statute? I keep on looking to the statute to try to figure out how it's connected to your theory of venue, and the answer is it's really not.
Well, I think the connection to the statute is through the statutory intent element. Remember, you have to specifically intend to commit the other crime. You have to specifically intend to obstruct justice. And that's the same as with inchoate crimes generally. When you intend to commit a further act, a further crime, and you have to there's more things that have to be done. If you take those other things after your first substantial step in an attempt or after the forming of the agreement, which is the crime, by the way, in conspiracy, but through an overt act, those things count for venue because it's part of the overall offense conduct as construed. We think that's the same thing for 1519 because of the statutory intent element. I'd like to also clarify a few things about 1512 and Lamar.
If he just shredded documents in his house, what's your theory?
That would be an offense.
I got that.
Right. We would not be able to, our theory, again, is based on Lamar's.
Just where could he be prosecuted?
Well, that would have to be in Seattle.
Even though
he had the intent.
Because on the text of the statute, I guess to follow up on other questions, I thought it was
well, you know what, actually.
Can I just finish the question? Conduct with the intent to cause an effect elsewhere. Conduct in one place with the intent to cause an obstructive effect elsewhere.
Yeah.
And I thought your theory might be you could be prosecuted in either place
I'm sorry,
But-
destruction is a little bit weird. Destruction of a document. That's a harder question because it is unlike where you're actually affirmatively placing the document into the investigation. And so I think our position would be a little harder. We might well argue that that would be covered, but I think it would be a
But your
fair amount
theory, as articulated here, wouldn't cover it, I gather. I mean,
yes, I think
let me just make sure I'm clear on what your theory is not. Your theory is not that conduct in one place with the intent to cause an obstructive effect in another is good enough to prosecute you in that other place.
right. You also need to actually produce an effect at the other place. You actually have. This is how
And that's not in
the
the
court
text.
understood its venue decisions.
So why isn't shredding doing it? I mean, what if what if these agents arrived at his house in Seattle looking for a document that he had upstairs?
Yeah.
And he threw it in the shredder when he went upstairs instead of creating it.
Yeah.
I don't understand there to be, under your theory, a material difference between placing a falsified document into the investigation versus removing one from the investigation from the standpoint of your theory. So going back to what Justice Kavanaugh just said, I'm now completely baffled as to what your theory is doing.
I think the difference is, and we may well argue that that's covered, but there is a difference, which is when you are sending it to the Northern District of California, you know, it's just like shooting a bullet to the Northern District of California.
No, he knows, because the agents from California arrived at his house saying, we're doing an investigation, and you know what? We have one piece left.
I understand.
It's a document that we cannot find.
I understand.
So
I
he
understand.
knows
We would likely run that argument that their venue is proper.
He knows that the California investigation needs the document that he is hiding. Now, I appreciate this is about falsification, but in my hypothetical, I don't understand why his intent to withhold or remove or destroy this document wouldn't count under your theory.
It may, but it's different. Our case is easier here because he's doing something affirmative as opposed to preventing something from getting to the investigation, right? There is a distinction. We may well argue that destruction of documents where you specifically know where you're preventing it from going.
My
Mr.
final
Yang,
question. Go ahead.
If you lost this case and we didn't want to rule out the hypothetical that Justice Alito gave you about fraud where it arrives at somewhere else, it seems to me that if we would not rule out that scenario if we simply looked at the statute and said the crime was complete when he created the document and it was irrelevant for purposes of the statute that he emailed it to the agents. That leaves open the question that Justice Alito said, which is the more significant one.
Yeah, I think if you were to construe what the nature of the crime is and say that there's nothing beyond, that's true, that would distinguish this case, for instance, from 1512I, because 1512I's venue provision, the express venue provision, applies to attempted obstruction. 1512C2, which Justice Sotomayor was talking about, does not simply address affected obstruction. It also expressly provides attempts to obstruct. So it's the same kind of situation we have here. This is like a specific means of attempt. So if Congress in 1512I specifically is telling you what the offense is, and that's different from this case, that would be, if you reserve that, then you allow for Congress to define the offense, because Congress has a lot of authority to define offenses.
Thank you, counsel. Justice Thomas, anything further? Justice Alito? Justice Sotomayor?
Who decides this additional element that's not in the statute, that you have to intend to produce an effect in a particular place?
It's not an element. It's not an element of the offense.
So who decides it?
Well, the case law, the court's
I
case law.
thought that we had a case not so long ago about what happens if an element's not submitted to a jury.
Okay. There's a distinction. There is a question about what offense conduct creates a crime. Those are elements. We're not saying this is an element. What we're saying,
Just
however—
answer my question. Who decides that issue?
Well, you decide what elements of the offense are by construing a statute, but our position is not that this is an element. Our position is that the crime that is committed, when you understand what the crime is, the crime doesn't have to be limited to offense elements. We know that from conspiracy.
When you read a charge to a jury that a crime was committed in the Southern District of New York, if a defendant says this crime wasn't, we usually say to the jury, tell us whether it was committed in New York or not. We don't let the judge decide it generally. So this is now a new step in this venue.
No, if there were, in this case, there was no request for jury instruction. If there's not a request for a jury instruction and jury finding in venue, there is no need for it. But you could in a future case if you requested it. They just didn't request it.
Thank you.
Justice Kagan?
Could you tell me, Mr. Yang, what the difference is between your theory and the Ninth Circuit's theory?
The Ninth Circuit, I think, isn't focusing as much on the kind of the doctrinal basis of having an intent and an effect in the district. I think they were just looking at the statutory intent element but weren't fleshing it out. Ours is a refinement. We don't think our position is that consistent, at least in the context of this case with the Ninth Circuit's, but they didn't have the same briefing as you have here in terms of fleshing out what the significance of the statutory intent element and what that means for the nature of the crime that is committed when you're analyzing venue.
Okay, thank you.
Justice Gorsuch?
1512I, your friend on the other side suggested that you think part of that might be unconstitutional. And I didn't think that was correct, and I want to make sure that's not correct.
No, there is a question about whether 1512I, certainly the prong that's relevant is, and this is reproduced at page 32 of our brief. It's a bit in the first paragraph towards the bottom third. Venue is proper in the district in which the official proceeding, whether or not pending or about to be instituted, was intended to be effected, right? So that is an intent, like you have to intend the district to be affected where the proceed. So that is arguably, you could read that one of two ways. You could say all that's required is an intent. Your focus, you know it's happening in the Northern District of California, you attend it, that's enough. That's different than our position here. We would
Correct.
defend that.
I got that. But
we
for
would
1512I, that's enough, right?
And we would. I'm sure. Well, yes, she gets to make this call, but I suspect we will defend that as a constitutional exercise of defining the crime. But you could also construe that. If you look at the legislative history, which we cite later down on the page, they talk specifically about killing a witness in Maryland, where the prosecution, where there was who was scheduled to testify in D.C. Right. And then we don't quote this part, but it says, they're providing jurisdiction where the obstruction is felt, it evokes the question of whether actually the effect is required too. And so there's an interpretive question. If you interpret it only to require intent, it's different. We still would defend it. But you could also interpret it to be exactly what we're saying here, which is you intend and have an effect in the district.
And then if you do not prevail in this case, obviously one of the concerns in writing the opinion will be ripple effects. Here's your opportunity to tell us, in the event you don't prevail, what you're concerned about for the next case. You've covered a little of that with Justice Alito, I think.
Yeah, I think this really comes up a lot in these kind of inchoate crime types of theories, particularly in the context of obstructions of justice, attempted obstructions of justice. So Chapter 63, which you discussed at some length in Pugin, I think. Congress has specifically addressed venue for purposes of 1503 and 1512 and 1512I. But there are other provisions where there are inchoate attempt crimes there too. Our view is that because Congress was simply resolving a circuit conflict in the favor of the majority, just clarifying where the offense was, that should be understood. You have to construe 1519 in the corpus of that body of law and construe it similarly. Now, it's possible you could construe it differently, and if that's the case, then our argument would not get us to home. But if you were to simply construe this provision saying Congress hasn't spoken to the nature of the offense as it has done in 1512I with respect to 1503 and 1512, that would leave open the door for Congress to clarify, speak more clearly with respect to where it thinks these inchoate crimes take place.
Thank you.
Justice Barrett?
It's a clarifying question that I hope is very simple. Did I understand you correctly to say that you don't think the intent to cause effects is enough to create venue in the place where the actus reus occurred?
Not on this statute. because unlike 1512I,
But it would under 1512I.
If you construe-
Intent to cause effects is enough.
If you view 1512I as only requiring just the intent, not the effect, then we would say, yes, that would be a sufficient basis for venue. So this case has both constitutional questions and it has statutory questions. And the two are always intertwined because the question for venue is where is the crime committed? But the question of what the crime is requires understanding what Congress intended for the crime. Now, the crime is, we know this cannot be the case. The crime is more than the offense elements. We know that to be the case. We know that to be the case from conspiracy. Overt acts
But
traditionally aren't.
conspiracy, Justice Gorsuch is right, conspiracy is a different kind of crime. I mean, it is continuing, and then you can be prosecuted for any of the acts within the scope of the conspiracy committed by your co-conspirators.
The Pinkerton liability point is important, and what it does is it sweeps in actions that you don't do because they're of co-conspirators, but it doesn't change the nature of what's the inchoate offense. The reason that offense continues is because it's not an agreement to just say we're coming to an agreement. It's an agreement with a specific intent to do more, to commit this further crime.
Okay,
That's the same thing that we have here.
Okay, one other question. Has the statute of limitations on this offense expired? If you don't know, I was just wondering.
I actually don't know. If you're asking whether we would retry him,
Yeah.
That decision has not been made, but I'll give you one fact that may counsel against it, which is he was sentenced to 42 months of imprisonment for all 6 of his offenses, including this. There was a sentencing error that the Ninth Circuit remanded for, and so even though upholding all the offenses, it went back for resentencing, and by that time he'd already served all 42 months, including the sentence for this crime.
This one. Okay.
So in terms of practical retrial, that would weigh as a factor that we would consider.
Justice Jackson?
In the case of U.S. versus Rodriguez-Moreno in 1999, at footnote 2, we noted that, quote, the government argues that venue may also be permissibly based upon the effects of a defendant's conduct in a district other than the one in which the defendant performs the acts constituting the offense. And we went on to say, we express no opinion as to whether the government's assertion is correct. So here today, do you at least concede that you're asking us for a new rule?
We don't think it's new because we think it's rooted in cases.
No, but the court reserved it in this prior case and said we express no opinion as to it. So today you're asking us to apply or to adopt the rule that you previously offered and that we expressed no opinion on. Is that correct?
Yes, but just because Rodriguez-Moreno didn't express an opinion on it doesn't mean that there aren't prior cases that speak to the issue, like Lamar, like Ford, which in extraterritorial context, which the question is basically the same, which is,
right,
did the offense occur in the jurisdiction?
As of 1999, the court had not understood itself to have answered that question, and the government was offering it, and we said we're expressing no opinion, correct?
No, I think that's overreading it. Expressing no opinion is different from saying we haven't resolved the question.
Thank you.
It's just not resolving it. There.
Thank you, counsel. Mr. Loss-Eaton, rebuttal.
So I think my friend really hung his hat on the analogy to conspiracy. His silver bullet, in his view, is that you can be tried anywhere an overt act is undertaken, further if it's a conspiracy, even for conspiracies where an overt act is not an element. And the problem with that view, in addition to the points that various members of the court have made about conspiracy being a unique, ongoing collective enterprise, is that if you look at the cases in which the court adopted that rule for conspiracy, it did not think about it at all in the terms that my friend is describing. In Hyde, in 1912, the court first allowed venue for a conspiracy where an overt act was committed, even though the conspiracy was formed elsewhere. And there, an overt act was an element. But the court explained the integral role of the overt act in giving the conspiracy life and continuing it forward. And it quoted a New York case from the 1830s that said, wherever the conspirators act, there they renew, or perhaps to speak more properly, they continue their agreement. So in allowing venue based on overt acts, the court conceptualized the overt act as itself being the agreement in a real sense, because an agreement without any overt acts really doesn't matter. It doesn't do anything. And so then in Trenton Pottery and Saucony Vacuum, which are the two cases that the court was summarizing in Whitfield, which the government cites so many times in its briefs, the court then applied Hyde to conspiracies where an overt act was not an element, essentially with no real analysis beyond saying, yes, that's still true here. In Saucony Vacuum, the court said that the overt acts supplied part of the continuous cooperation necessary to keep the conspiracy alive. So I think it's very clear from those opinions that the court conceptualized of an overt act, whether required as a standalone element or not, as being part of the actus reus of the conspiracy itself. And it was on that basis that the court allowed venue. And of course here, that is not true for the effects that the government is vaguely asserting happened in San Francisco. Beyond that, my friend returned a few times to the analogy of someone aiming a gun from Seattle at San Francisco and pulling the trigger. To the extent Mr. Abouammo was aiming anything at anybody, it was at the people who were sitting in his living room in Seattle. Whether the investigation was ongoing in San Francisco or anywhere else, I suspect was probably not top of mind. There were federal agents sitting in his living room in Seattle, and he wanted them to go away. And so to that extent, I think, Justice Barrett, it is the same as the airdrop analogy or printing out the paper and handing it to them. His conduct was in Seattle, and it was directed at people who were in Seattle. Nor is conspiracy an inchoate offense in any other way. The literal dictionary definition of an inchoate offense is solicitation, attempt, conspiracy. This is none of those. This is not an attempt offense because it applies only to a specific kind of conduct and not to a substantial step of whatever type. And it's not an attempt offense because it doesn't incorporate any objective offense whose elements you would have to think about. And I do think that distinguishes a lot of the hypotheticals that the court asked about. Justice Alito, the hypothetical that you raised about fraud that is attempted to be committed by transmitting a document. I think under most of the fraud statutes, and certainly once you start thinking about attempt, there's no problem with venue there on our theory, as long as that transmission is part of the actus reus that you're talking about. And for an attempted fraud, it would be, because that would be a substantial step. It might even be fraud itself, depending on what the effects were. So I don't think those kinds of situations are implicated. I do also want to emphasize, of course, all we're talking about here is where this crime can be tried. There's a temptation sometimes when you're talking about these issues to think that we're trying to immunize the conduct from prosecution. That is not what's going on here. All we're talking about is the appropriate place of trial, and that is where the offense was committed. A lot of the court's questions, I think, underscore the problems with the government's rule. I think, fully 80% of the questions that I heard were just trying to figure out what the government's rule is, how it works, and what relationship, if any, it has to the statutory text. And I think Mr. Yang's answers underscore that it is deeply unclear. The relationship to the actual statutory text and elements is extremely attenuated. And as you were getting at, Justice Sotomayor, it's very unclear how it would actually work. The facts that the government wants you to rely on to uphold Mr. Abouammo's conviction here were not charged in the indictment, and they were never found by the jury. On what basis, then, can you uphold the conviction even on the government's theory? And even if you adopt that theory for future cases, does that mean the government now has to charge those facts in the indictment and prove them at trial? It is a much simpler approach that will do no violence to the law, simply to say what the court has always said. We are looking to where you committed the essential conduct elements of the offense, and here all of the essential conduct elements were committed in Seattle.
Thank you, counsel. The case is submitted. Your argument next in Case 2583, Jules versus Andre Balazs. Mr. Unikowski.
Mr. Chief Justice, and may it please the Court. In Badgerow versus Walters, this Court held that federal courts lack jurisdiction over applications under Sections 9 and 10 of the Federal Arbitration Act unless an independent jurisdictional basis appears on the face of the application. In this case, the Court should hold that Badgerow's rule applies to all Section 9 and 10 applications, regardless of whether a pre-existing suit is on file. Nothing in the FAA distinguishes between those Section 9 and 10 applications that are associated with a pre-existing suit and those that are not. Moreover, Section 8 of the FAA contains explicit jurisdictional anchor language that Sections 9 and 10 lack. The Court should infer that this textual disparity is intentional, much as the Court relied on a similar inference in Badgerow. The Court should resolve this case based on the text of the FAA rather than based on Section 1367's related to standard. But if the Court reaches that issue, it should hold that there is no common nucleus of operative fact between the underlying suit and the Section 9 and 10 applications, which concern an arbitration award that did not exist at the time of the original federal suit. As Badgerow put it, the underlying dispute is not now at issue. In Kokkonen, this Court held that a settlement dispute is insufficiently related to the underlying dispute to warrant the exercise of ancillary jurisdiction, and the Court should rely on similar reasoning here in rejecting jurisdiction. I welcome the Court's questions.
Was there a pending federal case in Badgerow?
There was no pending federal case in Badgerow.
So don't you think that's a difference?
Well, that is indeed a factual distinction between this case and Badgerow.
Okay, so your client brings the federal case, right?
Yes.
The court then enters a stay so that the arbitration can take place.
That's correct.
The arbitration then is decided, and the parties come back to that very same court to confirm the arbitral award.
That's correct.
Or decision. And you're saying now that the jurisdiction of the court that you invoked is inadequate to decide this.
That's correct, Your Honor. I'm sorry.
Don't you think there's something odd about that?
I don't think so. I think our position follows pretty cleanly.
Do you think that that's consistent with Badgerow?
Yes, I think that the Badgerow rule, admittedly in the Badgerow case, there was no original lawsuit, and in this case there is. And that's why this is a separate case from Badgerow, but ultimately I think the same rule should apply.
So in Badgerow there was no jurisdiction. So the court said that there's no independent jurisdiction. And here you have a pending case in which the district court stayed its suit, its action, pending the arbitration. And you say that's similar to Badgerow, where there was no case.
No, it's a different case, Your Honor, but I think the same rule should still apply, whether or not you start with the text of the FAA or whether you start with Section 1367, as respondents would advocate. So maybe it's helpful if I start with the latter point before turning to the
What's
text.
the purpose of the stay?
The purpose of the stay is for if the case comes back and is not resolved in arbitration. So if you look at the text of Section 3, Section 3 says that if it turns out that the parties are in default of the arbitration, so the arbitration doesn't resolve the dispute, then the parties can come back to the federal court and the federal court can adjudicate the dispute. Or in the Spazzeri case, the court offered the example of a case where the arbitration breaks down. And so the case is stayed and the case might have to be reactivated in federal court. But here, there's an arbitration award. The arbitration is wrapped up. And so under Rule 8 of the Federal Rules of Civil Procedure, the court should dismiss the federal suit. It's quite similar to defense.
Counsel, doesn't Rule 8C1 say that an arbitration has to be pled as an affirmative defense?
Right.
So why aren't we thinking of it that way? Meaning, Rule 8 says in a litigation where an arbitration is sought, and that's what the federal action here was, it was a federal suit. The defense was arbitration controls. Why isn't this just a motion to confirm that the claim can't go forward?
So I think that dismissal would be appropriate, and because at the start of the lawsuit—
No, but you're arguing something else. You're arguing that not dismissal is appropriate, but confirming the arbitration award so it is final and settles the matter is not. Because that's what you're arguing.
We're arguing, Your Honor, that the court doesn't have jurisdiction to confirm the award as opposed to dismiss the federal case, because confirming the award is
But how can you dismiss it if you don't know if the arbitration award will be sustained, confirmed?
Well, the vast majority of arbitration awards are never subject to confirm or vacate proceedings.
Well, but the point still remains, how does a court know that it's a defense to the action until it has decided that it's a valid award?
No, because the award itself is the defense. It functions like a release. So if a plaintiff files a lawsuit and the defendant—
Well, you can't claim an arbitration award that has been vacated, correct?
That's correct. So what a court could do, a court might not know if the arbitration award is going to be later subject to confirm or vacate proceedings in state court. That could take several years. And so what a court would ordinarily do is dismiss the case. Theoretically, if the award is vacated, they would typically re-arbitrate it. They wouldn't necessarily go back to the federal district court. I'm sorry, Your Honor.
No. Counsel, I'm having trouble understanding your lawsuit because I thought Spizzarini answered it already. In Spizzarini, what we said was where a court does have proper jurisdiction over a Section 9 or 10 application in a pre-existing lawsuit, and there was, under Section 3, a pre-existing federal claim, so they had proper jurisdiction, the court that stayed the action can and should, for efficiency's sake, adjudicate those applications as motions in the existing lawsuit. So this is a motion in an existing lawsuit. That's what Section 9 and 10 are, over a claim that had jurisdiction, age discrimination. Why isn't this just a motion to confirm that?
Well, Your Honor, so in Badgerow, the court addressed the language in Section 6 about motions that Your Honor just referred to. The court said that it's not a motion. It says that the court's going to treat the application as a motion for efficiency's sake. So I don't think that the language in Section 6 carries the day.
But what Badgerow also said, it said something like jurisdiction to decide a case includes jurisdiction to decide a motion in a case. And isn't that what we have here? And Badgerow distinguished that from using the look-through method. It's just saying if you have jurisdiction over a case, you have jurisdiction over the motions in the case. That seems pretty, just a truism. And isn't that what's involved here?
I don't think so, because the court has jurisdictions to decide motions, just not necessarily every single motion that would result in the court entering a judgment that exceeds its jurisdiction. Because the judgment that respondents are asking the court to enter is not merely a judgment of dismissal, which of course the court can do. It's essentially transforming the arbitration award into a judgment which would allow respondents to enlist the court to execute the judgment against
Well, so
petitioner's
explain that.
assets.
What category of motions should not be included in the statement of if you have jurisdiction over a case, you have jurisdiction over the motions in a case? What category of motions is excluded from that?
Motions that would cause the court to enter a judgment that the court doesn't have jurisdiction to enter. Because in this case, the court undoubtedly had jurisdiction to dismiss petitioner's suit based on the fact that an arbitration award existed. What the court didn't have jurisdiction to do is enter an award in what was essentially a breach of contract suit that was beyond the court's jurisdiction. So absolutely the court could have dismissed the claim, but we think there's a difference between dismissal of a claim and transforming what is fundamentally a contract dispute into a judgment when the court lacks jurisdiction over that case.
But that's begging the question, I think, because isn't the purpose of Section 9 to give the court the ability to do that, to say that that's exactly what is supposed to happen? I mean, I've been a little confused by some of the representations that you made. You suggested that the vast number of arbitrations are not subject to, quote unquote, confirm and vacate proceedings. And I guess to the extent that you're suggesting that it won't be a dispute about whether or not the award is to be confirmed, that's true. But in most cases, when you have an arbitration, isn't there a circumstance in which some court, whether the federal court or the state court, is asked to convert the award into a judgment so that it can ultimately be enforced?
No, that's actually quite rare, Your Honor. The vast majority of arbitration awards do not result in subsequent judicial proceedings because it's so hard to vacate an arbitration award that in almost every case, the parties adhere to the award. Usually when the defendant wins the arbitration, usually the defendant doesn't come to court to confirm because the arbitration award itself generally has res judicata
All right,
effect.
but in a situation, this goes back to Justice Thomas's initial question, in which we already have a pre-existing lawsuit related to these parties, related to an underlying dispute that then gets resolved by arbitration, it seems peculiar, I think, that you would suggest that Congress set these rules up to insist that another court be involved in confirming that award so as to close out the initial case. I mean, the circumstances, you would, I think, have to agree that when we have a existing lawsuit that was stayed for the purpose of arbitration, it can't be one of the situations in which the arbitration can happen and everybody goes off into the sunset and the original court doesn't know what happened. So there has to be some closure to this. And I think under your rule, the closure you're positing comes from another court confirming the award, and that just seems very odd.
I don't think so, Your Honor. So first of all, I think that the closure happens when the award occurs and the parties come back to the federal court and say, look, we were able to resolve our dispute in arbitration. There's no more pending claims. There's no partial subset of claims that were stayed. The entire case is over.
But you do agree they have to come back to the federal court.
Of course they have to come back to the federal court.
All right, and so, but somehow you're saying that having exercised jurisdiction over this matter from day one at your request, Justice Thomas reminds us, the only way it gets resolved from the standpoint of wrapping this up is if the parties are just coming back to notify that another court has been engaged to do some sort of confirmation. Or you're saying the confirmation doesn't have to happen at all?
It doesn't have to happen at all. There's a 4-year statute of limitations, at least in California, on the confirmation proceedings. The court's not just going to sit there for 4 years to wait to see whether someone's going to try.
But if the parties want it to happen,
yes.
You're saying they cannot ask the court that took original jurisdiction over it to be the one to confirm.
Right. That's correct. They should go to the state court, and the court is free to stay the dismissal of the case if it knows that there's ongoing confirmation or vacator proceedings in a different court. And so, but all the court cannot do is transform what is fundamentally a breach of contract suit into a judgment.
Mr. Unikowski, why wouldn't there be ancillary enforcement jurisdiction, to be specific, of the kind that was that the court talked about in Kekkonen? It seems to me that if the parties come back, Kekkonen envisioned a situation in which the district court could, under 41, make it part of the terms of the settlement agreement that the district court could retain authority to enforce the agreement, and that wouldn't have been a problem. There would be no separate basis of jurisdiction there, right? It's a distinct action. It's a contract action, in essence, that's distinct from the underlying suit. Wouldn't be 1331 or 1332, for example. Why couldn't something like that theory apply here?
So first of all, that's not Respondent's argument, and that's not what the court did in this case. The Section 3 order did not purport to retain jurisdiction to confirm a follow-up arbitration award. It just said, pursuant to Section 3, that the case will be stayed until arbitration has been had. I also don't think a court could do that. I don't think a court could circumvent the limitations under Section 3 by entering an order that's broader than Section 3, especially given that you have Section 8, which explicitly authorizes the retention of jurisdiction in maritime cases, and Section 9 does not have similar language. I also think that a court doesn't have unlimited authority to retain jurisdiction under Rule 41. I think the analysis is somewhat similar to the analysis in cases involving consent decrees. So in certain cases, a court can take a settlement and embody it in a judgment, but the court can't just rubber stamp it. The court has to make an independent assessment of things like whether or not the settlement advances the objectives underlying the statute, and only then can it really give the settlement the imprimatur of the court's authority. And so we think that a similar analysis would have to happen here, except it can't, because in an arbitration award, the court really isn't considering on its own the viability of the award. It's just assessing whether the arbitrator exceeded its powers. So in a nutshell, I don't think the court did that in the Section 3 stay. I don't think the court could have done that either in the Section 3 stay.
When it comes back, if the case were a federal question case to begin with, and it comes back, there's no federal question, therefore it goes to state court, correct?
So what happens is the court, yes, so there was a federal question at the outset.
Right.
And so the arbitration award functions like a release or res judicata. It's a defense saying this case has been resolved in a different form.
Got it. So the confirm or vacate, though, goes to state court in those cases?
Yes.
if you come back and the original jurisdiction was based on diversity of citizenship, you still have the diversity when you come back.
Correct. The face of the application.
Then you go to federal court.
You can, because there's an independent jurisdictional basis on the face.
It just strikes me as odd that if the original case, to Justice Thomas's question, was based on federal question jurisdiction, you'd end up in state court to confirm or vacate, whereas if the original jurisdiction was based on diversity and that still exists at the end, you would end up in federal court. That seems like an odd result.
I don't think it's so odd because the follow-up dispute at its core is a contract dispute. The parties aren't debating anymore the merits of the federal claims. That's been resolved by the arbitrator. All the parties are addressing—
There's still a pending federal case based on federal question jurisdiction.
That's true, but once the arbitration is over and there is an arbitration award and we're at the stage where the court is considering a Section 9 or 10 application, the issue is not whether or not the federal claims have merit or not. That's already been resolved by the arbitrator. The issue is whether the arbitrator committed fraud, exceeded its powers, things that have nothing to do with the federal claims. And Badgerow's insight from our perspective is that at core is a contractual dispute.
Mr. Unikowski,
Yes.
I'm sorry, please.
Go ahead.
That was my question, too. And I'm struggling to come up with a reason why Congress in the Federal Arbitration Act might have wanted diversity cases to remain in federal court for confirmation proceedings, but federal question cases to go to state court. You're a very clever fellow. What might you imagine Congress's policy judgment have been in that, for that?
I think it's a similar policy judgment that underlay Badgerow, and I do recognize that in Badgerow there was no pre-existing federal suit. But nonetheless, in Badgerow, the underlying question was federal. Like the question was whether the arbitrator's resolution of federal claims complied with the Federal Arbitration Act. And the court said that at core, that's a contract dispute. And courts only have jurisdiction over contract disputes when the requirements for diversity of citizenship are satisfied. And so that's ultimately the distinction.
Okay.
And as a policy matter, I mean, what's happening in this case is ultimately the court is entering a judgment. The reason people typically seek to confirm arbitration awards is because they want a judgment they can execute on. That's why most confirm or vacate proceedings are when the plaintiff wins and they have a judgment and they want to use the authority of the court. And so, state courts are very good at entering judgments and enforcing them. That's why Congress made a different decision in Section 8 cases where the court seizes a ship, because in that case it makes perfect sense for the federal court to enter a judgment because it's already has possession of the ship. So I think that's a sensible reason Congress would have said that we want the federal court to enter the judgment.
Thank you. I think Justice Kavanaugh had more.
I'm sorry.
Am I right, Mr. Unikowski, that your understanding of where Section 5 and 7 would continue to apply? It's really only in these diversity suits again?
I think so, but I think there's an argument possibly the other way that wouldn't apply in this case. So I think the correct answer, like my ultimate bottom line position, is that yes, there has to be an independent jurisdictional basis in Sections 5 and 7. Section 4 has look-through jurisdiction, Section 8 has the anchor, and if such language isn't present, there needs to be an independent jurisdictional basis. Now, I think there's a reasonable contrary argument that wouldn't apply here under the second head, as Kokanen puts it, of ancillary jurisdiction. There is an argument theoretically available that if the court compels arbitration, but there's no arbitrator, appointing an arbitrator is a way of enforcing the order compelling arbitration. So I think a court could reach that conclusion, which wouldn't apply here because the arbitration is over. Like the order compelling arbitration has been carried out. So I think the court can reserve this question until the next time it has the opportunity to decide whether a particular type of
Here,
arbitration—
the court didn't order arbitration because it thought it didn't have the power to.
That's correct. It stayed, but—
So under your theory, your answer to Justice Kagan is it doesn't have any power.
No, but I think arguably, even in a case where the court stays pending arbitration like this one, the premise of the stay order is that the arbitration will happen. Otherwise, the arbitration will last forever. And so court— This is not my bottom line answer, but I think a court could say that the court is, in a sense, enforcing the order staying arbitration by appointing an arbitrator to make sure the arbitration happens. That's just a way a court might avoid that result. But ultimately, I think that the FAA says what it says. The court, Congress included jurisdictional language.
Thank you, counsel.
Yes.
Counsel, no one—
Go ahead.
No one, I think, disputes the court's jurisdiction to enter a consent decree. So why isn't confirmation of an arbitral award analogous, since both involve taking a private resolution and making it a judgment of the court?
Because consent decrees require a degree of judicial involvement that doesn't exist when the court confirms an arbitration award. There's a rich body of law from this court about when a court can enter a consent decree, and the court has made clear that the court has to undertake an independent assessment of considerations such as whether or not the terms of the consent decree advance the objectives underlying the law at issue in the complaint, and whether there's a sufficient nexus between the terms of the decree and the complaint. Obviously, there's a lot of discretion to the parties, but still, precisely because it's a judgment of the court has to undertake an independent assessment of the terms. That doesn't really happen under the FAA.
But is that just because it has been, those kinds of assessments have been given to the arbitrator and sometimes even at the court's direction?
I don't think so. When the court confirms an arbitration award, the court isn't independently assessing, for example, whether the arbitrator's award furthers the goals of Title VII or the ADA or whatever federal statutory claims are being advanced. The court isn't sort of taking a second look at the merits. All the court is doing is assessing whether the arbitrator exceeded its authority under the arbitration agreement and engaged in certain specified types of misconduct. So I think that the degree of judicial involvement under on Section 9 and 10 is much less than what this court has said is necessary to justify the court transforming a pure settlement into a consent decree. So that's why I don't think that analogy carries over.
The Second Circuit and the District Court both thought that our statement in Cortez Bird kind of made this simple, because there we said, we have, however, previously held that the court with the power to stay the action under Section 3 has the further power to confirm any ensuing arbitration award, end quote. So I know you're going to say that was out of context, but that statement on its own would resolve this, wouldn't it?
On its own, that statement is favorable to respondents, and I'm going to say what you said I was going to say, which is that if you read that whole paragraph, it's actually making a very different point, which I think ultimately supports our position, which is that Congress wouldn't have intended a court's ability to decide a Section 9 or 10 application to turn on whether there was a pre-existing suit on file. Right? So the question in Cortez Bird was one of venue, whether venue existed only in the jurisdiction in which the arbitration occurred or was broader than that. And the proponent of narrow venue conceded in that case that if there was a Section 3 stay, that court could exercise jurisdiction over the Section 9 and 10 application, but argued for a different result if there was no Section 3 stay.
Different question. Section 10 in state court. Thoughts?
Yeah, so, I mean, we view that Sections 9 and 10 as joined at the hip. Like, Section 9 refers to confirming the award unless there's a Section 10.
The standards set forth in Section 10.
Oh, the court reserved that question in Badger.
Yeah, what are your thoughts?
My thoughts are that it doesn't have to be exactly identical to the federal standard, but if the
Does it have to be close?
Pretty close. Like, if the court authorized...
Pretty close?
Yeah. Basically pretty close. I mean, the court hasn't addressed this. Look, if the state court authorizes de novo review of an arbitration award...
Because the state court theoretically could have very different standards than the arbitration awards thrown out, but then the new suit, again back to Justice Thomas's first question, not the new suit, the suit comes back to federal court then after the state court's thrown out the arbitration award.
So typically that's not...
a strange system.
I don't think it would come back to federal court. Typically what would happen is they would arbitrate the claim again. Like the effective, for instance...
It depends what the state court said in tossing the arbitration award, right?
Well, not really, because if the federal court, if the case is arbitrable, then, and the state court says there's some defect in the arbitration proceeding, but the case is still arbitrable, you'd presumably go back and re-arbitrate. Theoretically, the parties, for example, might stipulate that if the award is vacated, they're just going to give up on arbitration, and then they could go back to federal court, either file a Rule 60 motion, or the federal court could opt to wait to dismiss the case until the state court's proceedings are done, and it could be reactivated in federal court.
Do states have pretty close standards?
They do. I don't think that's, I'm not aware of any state that diverges significantly, like there's like minor wording differences sometimes. I think there'd be an obvious preemption problem. As I said, the state authorized de novo review of an arbitration award that would be contrary to Section 2's substantive standard that arbitration agreements should be enforced. But if there's like very small distinctions or differences in things like the statutes of limitations, I don't think that those types of differences would necessarily...
I have another question also just about practice here. Are most of these 9 and 10 applications brought as freestanding applications, or are they connected to a federal suit in the way that this one was?
I mean, I've read a lot of cases. I'm not sure of the empirics there. I think they're mostly brought independently because usually there's not that much dispute over whether parties have to arbitrate, but I've seen on both sides. I don't know a specific number.
And is there a way in which your theory or Mr. Geiser's theory would push the practice in one direction or another in a way that either made sense or didn't make sense?
So yes, I appreciate the opportunity to say that. So one of the concerns about Respondent's position is that it'll create an incentive in every case to file a freestanding motion to compel arbitration or do something else to get to federal court if you want to have that anchor. And this court remarked on this in both Vaden and as well as Justice Breyer's dissent in Vadro. Vaden said it would be a totally artificial distinction to distinguish between Section 9 and 10 applications associated with pre-existing suits and not so associated. And Justice Breyer's Vadro dissent reiterated that language, that the jurisdictional anchor would create that totally artificial distinction.
Thank you, counsel. Justice Thomas, anything further? Justice Alito?
Well, just out of curiosity, do you think we should ask Claude to decide this case?
No, I adhere to the wise judgment of this court.
Justice Sotomayor?
You're suggesting to me that people who have stays in place typically don't move that court for motions to confirm the award, that they usually go to somewhere else for that?
No, I'm suggesting that usually motions to confirm the award aren't necessary, especially when
No, I understand that. But when there is a stay, what's the number of cases that go to another court?
Well, there's a circuit conflict on this issue, and it's true that most of the courts have gone with Respondent's position, but most of those opinions are sort of not very, there's not a lot of reason.
It doesn't matter, but the vast majority, I'm not aware of a Section 3 stay case where the other side has gone to a different court to confirm the award.
Well, I mean, there's a circuit conflict on this issue, and
so where they're not permitted, that's what drew us to take this case. Where they're not permitted to, they can't.
Right.
But the point is, when they are permitted, they stay in the court where the stay is granted, correct?
right. It's likely that if the court rules for Respondents, people don't want to pay a second filing
All right.
fee, so they'll probably go.
You talk about your fear of people choosing litigation, choosing a venue, and not arbitrating in order to get a venue.
Yes.
You have to be Houdini, not Houdini, you have to have magical powers to know whether you're going to win or lose, right?
No, you can just bring a freestanding Section 4 motion to compel arbitration, which this court held you could do in Vaden.
Well, you didn't bring it.
No.
You had to have the foresight. You went to New York, a jurisdiction that had no connection to the dispute, where the dispute happened, and only because you've lost in New York are you wanting to get out of New York.
Your Honor, the facts of this specific case don't present the practical concern.
Well, but they present the practical concern that your fear requires a lot of predictions that parties are unlikely to engage in, because right now most of them don't fight where they're going. They just do arbitration, and most of them don't fight awards. They accept them.
Right, but the point is, look, if I am advising a client, and the client says we're about to arbitrate, and we might need down the road to file an application to confirm or vacate the award, and the client says, I'd rather be in federal court. In every case, I would say, let's go to federal court.
You know, I practice a lot of arbitration law. I don't know a client who ever said that to me. I want to file it in this court. In case I win the award, I want to be in federal court. Thank you, counsel.
Justice King, Justice Gorsuch, Justice Cameron, Justice Barrett.
Just as a practical matter, under your theory, the stay is in place, you have the award, you want to confirm it. Do you have to do you file a motion to dismiss first in the district court before you go to the state court to try to get the arbitral award confirmed or vacated?
No, I don't think you necessarily have to do that. I don't think there's a specific order of operations, because we view this as the arbitration award as a non-jurisdictional defense akin to res judicata or release. I think the federal court could opt, if it knows that there's an ongoing vacate or confirm proceeding, it could opt to just wait to dismiss the federal suit until those proceedings wrap up. I don't think there's necessarily an order of operations that's required.
Okay, thanks.
Justice Jackson?
Can I just take you back to the original questions that I think Justice Sotomayor and Justice Kagan asked about treatment of this as a motion?
Yes.
And Section 6. And I know that you referenced Badgerow's statement that the applications will get streamlined treatment as a motion. But Badgerow cited a case called Hall Street Associates for that proposition. It quoted from Hall Street, and that entire quote says, "will get streamlined treatment as a motion, obviating the separate contract action that would usually be necessary to enforce or tinker with an arbitral award in court." So it appears, at least as of Hall Street, the court understood the way that this worked, that the reason why you're treating this as a motion is that it would mean that you wouldn't need another contract action in another court in order to enforce the award. Why doesn't this undermine the argument that you're making now?
Because I interpret that language in Hall and Badgerow differently. Section 6 does not distinguish between applications in a freestanding case and applications that are associated with a pre-existing case. It's just a single rule that covers all FAA applications that says that they'll be treated like a motion. And what the court said in Badgerow was, what that means is not that it is a motion in a case in which there's jurisdiction. It'll just be treated like one.
I understand, but in Hall it says the reason why it's treated as a motion is because it will obviate the separate contract action. And what I'm confused about is how that could be consistent with your vision, which would require a separate contract.
Well, I think there has to be jurisdiction over the contract action. If there isn't jurisdiction, the court couldn't hear it. And if there is jurisdiction, then yes, the court could hear it as a motion, and it would save a lot of time and effort. And Section 9 and 10 has these very specific service of process provisions. And if the defendant is within the district, it's sort of easier to serve process than it is normally. And I think Section 6 is similar with that streamlined procedure, but that doesn't mean there is jurisdiction. It simply talks about what happens if there's jurisdiction.
Thank you.
Thank you, counsel. Mr. Geiser?
Thank you, Mr. Chief Justice, and may it please the Court. Consistent with decades of established doctrine, federal courts with pre-existing jurisdiction may resolve related claims in the same pending case, and nothing in the FAA or Badgerow overrides the ordinary jurisdictional rules in this setting. A federal court already vested with original jurisdiction has obvious power to hear FAA motions in that pending action. There is no need to ask if there is a redundant basis for original jurisdiction because jurisdiction already exists, and any FAA motion falls squarely within a court's supplemental jurisdiction. This follows under the plain text of Title 28. It adheres to ordinary jurisdictional principles, and it promotes the FAA's purpose and objectives, including facilitating the judiciary's supervisory role in enforcing awards. Petitioner's contrary approach contravenes Section 1367. It is at odds with Badgerow, and it invites unworkable and untenable results. Respondents are simply asking to go back to the same court to enter judgment and dismiss petitioner's case without having to bifurcate these proceedings, file new state law litigation, and endure a parallel federal appeal, and chase down petitioner to finally bring this case to a close. I welcome the court's questions.
How exactly does 1367 apply to a Section 9 application where there are no apparent claims? Where are the claims in an application under Section 9?
Well, I think it applies exactly under Section 1367. You have an existing federal case which vests original jurisdiction. The Section 9 claim, if you look at it as a state law analog, as a contractual resolution of the claim as Badgerow did, then there would be supplemental jurisdiction over that state law claim. Now,
but it's not a state law claim.
It isn't, which I think is all the more reason that there clearly is jurisdiction under 1367. 1367 isn't limited to state law actions. It's any claim that's so related to the original claim that it forms part of the same case or controversy.
Well, but it's the same nucleus of operative fact. That's the test. How is this the same nucleus of operative fact? It seems to me completely two different sets of facts.
I don't think so, Your Honor. It's the contractual resolution of the pending claim in the same case.
Well, but Mr. Geiser, I mean, I think Mr. Unikowski said this, what the second case is going to be about is something like, did the arbitrator commit fraud? It's going to have nothing to do with the actual claims in the case. You're not allowed to relitigate those.
You're not, but I don't think that matters. I don't think the test are the elements coterminous. It's, are the claims so related they form part of the same case or controversy? The arbitration award is an affirmative defense in the case. It's hard to see how something can be an affirmative defense to the claim in the case without being related to that case.
Yeah, I think that's just not 1367's focus. 1367 says we're not going to look sort of as an abstract matter as to whether two claims were brought by the same parties or have certain features or are connected with each other in a certain way other than one particular way, which is, are the facts the same in these two claims? And the facts are not going to be the same in these two claims.
Well, not all the facts, but you're still asking, this is a contractual resolution of the claim that is pending. It's like saying that the judgment in a case is somehow unrelated to the original claim that produced the judgment. I think it doesn't have to be the same. We absolutely, I agree with my friend that these claims will not overlap. Often they have nothing to do with each other.
Yeah, common nucleus of operative fact, and often they have nothing to do with each other. I would say almost always they have nothing to do with each other. How could that possibly be a common nucleus of operative fact?
Well, it doesn't. It's not that every fact has to share the same, original atom. It's is there a common nucleus of operative fact?
It's the great-great-grandchild of the original claim, kind of attenuated on. I mean, what is it a claim? I mean, you characterize it as an affirmative defense, not a counterclaim, not a subsidiary claim. It doesn't seem like it's a claim.
Well, it's resolving. I think it is resolving the claim in the sense that it is contractually, disposing of the claim that has been brought. Now, I will say that there's an entirely different way to look at this, and part of the problems that the FAA, as this court has acknowledged, is unique. We have an unusual situation where we have a federal right under a federal statute that doesn't give rise to federal jurisdiction. And one analog is to say that the arbitration award is like a contractual settlement. So then confirming the award under the FAA, even though it's a federal statute, is like resolving a state law contract dispute, sort of like Kekkonen. Another analog, though, is just to say this is the federal directive on how a court decides what to do when the claim that's pending before it is now settled. So in the same way that Congress can provide rules of decision in Rule 23 to say if you're going to settle a class action, do you accept the settlement or not, or attach conditions to Rule 41, or do exactly what the court contemplated could have happened in Kekkonen.
And if that's the way you're looking at it, are you drawing on original jurisdiction then?
Yes.
That's not a supplemental jurisdiction idea.
Then we don't need supplemental jurisdiction,
Right.
Which is why we offered two competing paths in our brief that lead to effectively the same result.
It's not ancillary jurisdiction, just to clarify. You're saying that the original jurisdiction, the 1331 hook, is carrying you all the way through.
I think that is one way, I think in a sensible way to look at it. I think it's actually the way that, that Cortez Byrd was contemplating, saying, of course, once you have an original case and you've stated under Section 3, then of course you have jurisdiction to resolve what's a motion in the pending case, just as Justice Kagan and Justice Jackson pointed out, to decide what to do with that contractual resolution of the single pending claim.
You heard his response on Cortez Byrd. Do you want to, your friend, you want to react to that?
Sure. So I think I think my friend is correct that Cortez Byrd was citing Marine Transit, which is a Section 8 case. But Cortez Byrd was not a Section 8 case. So the way I read Cortez Byrd, and I think the way the courts have read Cortez Byrd, is the court was importing this common sense, intuitive proposition that happened to arise in the Section 8 context and putting it into the Section 9 through 11 context. And Cortez Byrd, by the way, was a 2002 decision. It's been decades on the books. Courts have construed it exactly the same way. It was only until the Fourth
Most of the courts have gone that way, right?
Well,
Most of the courts of appeals.
I think every court has gone that way. The only one that hasn't was the Fourth Circuit, which, with all due respect to the Fourth Circuit, I think just profoundly misread Badgerow.
That's why I said most.
Yeah, and that is, and in fact, when we say most, that is effectively, as far as we're aware, the only court that has gone the other way. I'm not aware of a single court before Badgerow that's gone the other way.
Mr. Geiser, you've laid out two paths for us. One, the supplemental jurisdiction path, reliant on a statute that could never be accused of being overly precise. The other would be the original jurisdiction path. I know what your answer is going to be, and it's going to be they're both great, Your Honor. But which one do you think, if forced to choose, is the safer route, and why?
I mean, I really do think that they're both great, and I think that they both work. So
any lawyer who doesn't say that isn't worth his salt. You wish to win, and I understand that, but.
I think that, and it really is that it's half in one hand, half in the other. I would say that you could say it's part of the original jurisdiction. That's just a very easy way to resolve it. We're in the same pending case. We're trying to dispose of the original claims.
Your brief, if I read your brief is a supplemental jurisdiction brief.
Well, we did make both arguments, and we did supplemental jurisdiction.
You made one in a couple of paragraphs, and you made the other in 50 pages.
Well, we thought
that might be a slight exaggeration.
Well, no, we thought one was so obvious that we were trying to help the court if it decided to go the other way. But I do think, though, that the reason what we were fronting 1367 is because of the analogy that the court drew in Badgerow. Is that if you do think of this as a contractual resolution of the claim, and then you think of it as a dispute over that contractual settlement, then it does look like it's a little bit different. And I do think that they clearly arise out of the same ultimate, common nucleus of operative fact. It's clearly the same case or controversy because, again, it is literally resolving the single controversy before the case, which is why if you looked at how courts typically dispose of these actions, if they do retain jurisdiction, as every court outside the Fourth Circuit does, is that they say, if we confirm the arbitration award, you enter judgment on the arbitration award and judgment on the underlying claim. You do it in one fell swoop because it is effectively the same action.
Can you respond to your friend's comments of picking up on Justice Breyer's dissent in Badgerow about incentives?
I think that it's really hard to see how there's an incentive to file an anchor suit for any number of reasons, including that parties aren't doing that. Again, Cortes Byrd's language, and my friend can quibble whether it was overstated or improper, but Cortes Byrd's language was unequivocal. If you imported that sentence into this decision, you could write a one-page opinion with a holding that says we've resolved this in Cortes Byrd. That was in 2002, and there hasn't been a single identified case of someone filing an anchor suit. And I think it's for similar reasons that Justice Sotomayor pointed out. It's a very odd litigant who is choosing an original venue not to litigate the case and not to compel arbitration, which is sometimes heavily contested, and that's what you'd be worried about, but thinking months or years down the road, what is this going to look like once we get that award? Do I want to confirm it or vacate it? And I'd rather be in federal court. So I'm going to file this preemptive federal action. And for some parties, it's not even an option. If you're a plaintiff and you file the original lawsuit to litigate, then it's not even clear. You might have, first under Morgan versus Sundance, you might have forfeited your arbitration rights because you're trying to litigate. And if the defendant doesn't move to compel arbitration, you're then out of luck. You showed up there. It's your lawsuit. So I don't think that those incentives actually play out. And if you're concerned about the practical consequences, I would look at the practical consequences of where my friend's position would lead courts and litigants. It would create this odd situation where a party finishes in federal court after the stay. Now apparently the federal court will either dismiss the case without knowing whether those claims are actually resolved or not, or they stay the case to wait, as my friend said, potentially several years for the post-arbitration motions to play out in state court. Now, if the federal court does dismiss the case, now we have an even worse situation. Now we have parallel proceedings. You have a federal appeal potentially contesting the pre-arbitration motion to compel arbitration, because you can't take that until you have a final judgment in federal court. And then you have the same litigants going to state court to challenge what happened in the arbitration itself. So instead of having one proceeding up and running where parties have already paid a filing fee, they've found the defendant, they've effectuated service, they've maybe fought about venue, they fought about personal jurisdiction, everything is up and running where you can resolve it in one proceeding, take one appeal. It's nice, neat, and tidy. Instead, you have now competing litigation in separate tracks in different court systems. I don't think that's what Congress intended. I think that would create what Cortes Byrd described as attributing to Congress a taste for the bizarre, and I do think that would be a bizarre situation.
I agree with you that it seems more practical and tidy to do it the way that you just described. I'm wondering if you fronted the 1367 argument, because in some ways it provides, I still struggle with the common nucleus of operative fact and exactly where is the claim issues, but it provides a theoretical grounding. When I'm trying to think about 1331 just by itself, I'm trying to figure out what in 1331, if I'm blinded, I'm taking 1367 out of it, justifies the adjudication of this separate contract dispute.
I think it would be exactly the same way that when a court invokes, say, Rule 23E, it doesn't say, do I have separate jurisdiction to decide whether to accept this settlement or not? Or whether in the Rule 41 context, do I have jurisdiction to decide whether to retain, jurisdiction over the settlement to police it or to put it in the decree? I think it is part of the original power to dispose of the claim.
And so under that formulation, we're thinking of it more as a motion than a claim, which would be inconsistent with the 1367 theory, right?
Debatably. I think 1367, I think, is been described as quite broad. I think it's pretty capacious. I think it can cover lots of things. But luckily for us, Section 6 under the FAA says treat these as motions. So if you want to treat this as a motion covered by original jurisdiction, you have a very easy path to do it. It's consistent with Cortes Byrd. It's consistent with the fact that Section 6 says treat this as a motion. I think it's even consistent with Kekkonen. And again, just to be clear, Kekkonen was dealing with a far more aggressive assertion of ancillary jurisdiction. That was a dismissed case, and the parties were trying to get the court to re-invoke jurisdiction to decide something.
Okay, well, let's talk about Kekkonen. What about Kekkonen's kind of bucket two, where Kekkonen says, well, it would be different if the court had reserved in the dismissal the authority to enforce the terms of the settlement? You didn't push that particularly hard. Why?
Well, we did, and I'm sorry if it wasn't clear that we did. Here, it's even better. You don't have a dismissal. You have existing pending claims in a pending case. So Kekkonen, again, is a much harder case. There, the court saying, I'm going to dismiss this action, and I'm going to retain jurisdiction just in case something happens down the road. Here, we have pending federal claims. And you don't even know what to do with these claims. So I think with all due respect to my friend, I think he's incorrect. To dismiss the case without knowing whether the arbitration award will ultimately stand doesn't make any sense. If the award is ultimately vacated, the parties could very well say, you know what, that was a waste of time. Let's just litigate in court.
So is ancillary jurisdiction of the sort, ancillary enforcement jurisdiction of the sort that Kekkonen talks about applicable here? Is that a coherent way to think about this?
I think you could. Now, I do think that this raises a slight complexity about to the extent 1367 has displaced or captured ancillary jurisdiction, but I think the very fact that Kekkonen contemplated that a court could retain jurisdiction to decide those subsequent settlement disputes suggests that this would be covered then by 1367.
Well, that's why I said enforcement jurisdiction. I think that's different because nobody really disputes that a court could exercise ancillary enforcement jurisdiction over, say, a contempt proceeding. So that would be different. It wouldn't be subsumed by 1367 in the same way.
We think that works perfectly well, and I think it's a sensible way to look at this. I do want to address this very quickly, the Section 8 argument about does the text of Section 8 somehow preclude jurisdiction under 1331 or 1332 or 1367? And I think it quite clearly doesn't. Section 8 is a maritime provision, and it starts off by saying notwithstanding anything else going on. So this is Congress's attempt to say we're creating a self-contained unit to deal specifically with Admiralty, and we're going to provide specific rules for that context. In order for that to preclude the assertion of jurisdiction elsewhere, because again, we're not relying on the FAA for jurisdiction, we're relying on Title 28. It would have to show that Congress in Section 8 was thinking, I'm going to foreclose jurisdiction for every non-maritime case, the overwhelming swath of cases that arise under the FAA, simply by creating a specific rule of decision for that narrow context.
Mr. Geiser, just going back to this, it's just a motion in a case. If you have jurisdiction in a case, of course you have jurisdiction over this too. I mean, this is a very unusual kind of motion, right? It's a motion which could have been brought as a freestanding suit, which is essentially a freestanding suit, and a freestanding suit in which there would have been no jurisdiction. So notwithstanding that there's this sort of like unusual posture in which it appears as like a motion in another suit, we all know that it's a different suit, and a different suit in which there is no jurisdiction. So why does that carry you home?
Well, I think it's not quite just an entirely different suit because, again, it's a motion with a different nature of claim to resolve the original pending claim. So I do think, again, just like Rule 23E is not a different suit, the party settled class
I think
claim.
what I mean of it as a different suit is it's a bunch of contract claims. Let's say it's about, like, the arbitrator committed fraud, and so the contract is invalid. That's what this suit is. That's what this motion is. Call it whatever you want. That's what this thing is. And that has nothing to do with the employment action that's kicked off this whole thing.
Except for the fact that it is resolving the employment action that kicked off this whole thing. So again, that's why I think it's really hard to say that resolving a claim is unrelated to the claim. Even if the reason you resolved it, maybe you settled because they offered you a lot of money, or they gave you something that you wanted. That has nothing to do with the underlying factual allegations. It's still resolving the claim. And I think that shows why it's part of the same case or controversy. I mean, it is literally resolving the case or controversy. And again, I think a contrary view on that would say that an affirmative defense to a claim in a case doesn't arise or relate to that same case, which it's hard to even articulate the concept because it just doesn't make much sense. But again, I think that's why we tried to offer two different paths in the brief, because depending on which way you look at it, we're dealing with this odd hybrid that the FAA has set up. Again, no one has ever applauded Congress for creating, the world's cleanest statute. It's 5 pages of the U.S. Code. I think this court is burdened with 2 or 3 cases a year, it seems, under the statute, going back I don't know how many years. But looking at it here, I think what Cortez Byrd acknowledged, 2 decades ago still holds. Of course, if you have jurisdiction to stay the case under Section 3, you have jurisdiction to process it at the end of the day.
Thank you, counsel. Justice Thomas, anything further? Justice Alito? Justice Kagan? Justice Gordon? Justice Barrett, anything further? Justice Jackson? Thank you, counsel.
Thank you.
Rebuttal, Mr. Unikowski?
Thank you, Your Honor. I'd like to first begin with the discussion of Section 1331, which didn't occupy much of the briefing, but did occupy much of the discussion this morning. I don't think that confirming the arbitration award can be justified under Section 1331, because that judgment is not the resolution of the original claim. The original claim was a federal employment claim, and the resolution of that claim is that the claim cannot proceed in federal court, because the parties agreed to arbitrate that claim. So just as a court dismisses a claim based on res judicata or release when it turns out that the parties have adjudicated the case in a different forum, the appropriate resolution of the federal claim is to dismiss it because the federal court can't hear it when it's being decided elsewhere. But confirming the arbitration award is different. It's transforming the arbitration award into a judgment, and the practical difference there is that it allows respondents to execute a money judgment against petitioner. So what happened here is that the parties agreed to arbitrate, and then this arbitrator entered the sanctions award, which is a money judgment against petitioner, and then confirming the award transforms that contractual resolution of the claim into a federal judgment. And that's not a federal judgment. The money judgment against petitioner, which is the real practical effect of confirming this award, is not resolution of the original claim. It's transforming the parties' agreement to adjudicate this in a contractual method into a federal judgment. That's why I think extra jurisdiction is needed. Section 1331 doesn't do the trick. And so then you get to Section 1367, and as some of the questions from the bench today made clear, there is no common nucleus of fact. I think Kokkonen is directly on point on this issue. I understand in Kokkonen there was a dismissal rather than a stay, but as to the first head, as Kokkonen called it, of ancillary jurisdiction, the court said it, quote, permits, quote, disposition by a single court of claims that are in varying respects and degrees factually interdependent, which is very similar to the 1367 analysis. And then the court held that the facts underlying respondent's dismissed claim for breach of agency agreement and those underlying its claim for breach of settlement agreement have nothing to do with each other. It would neither be necessary nor even particularly efficient that they be adjudicated together. And that reasoning is right on point here because at core, the arbitration award is similar to a breach of settlement agreement claim. It's a contractual way of resolving a dispute. And the core insight from Kokkonen is parties that agree to resolve a dispute via contract who later dispute that contractual resolution are adjudicating a different dispute from the underlying federal dispute. I'd just like to say a few words about Cortez Byrd. The court has said that the court has cautioned against giving too much credit to drive-by jurisdictional rulings. And I think this is just the canonical case of a drive-by jurisdictional ruling. So first of all, jurisdiction was conceded in that case under diversity jurisdiction. Also, there was no Section 3 stay at all, so the jurisdictional anchor issue was doubly not presented. Meanwhile, the court was talking about what it had previously held, in this case, Marine Transit, that everyone agrees is irrelevant. The court was also talking about a venue issue, which was also conceded by one side in that discussion. And all of this in service of making an argument that's ultimately the argument we're making in this very case, which is that Congress would not have intended for a court's authority to hear a Section 9 or 10 stay application to depend on whether or not there's a pre-existing suit on file. So I do understand that lots of lower courts have followed that statement from Court Disbird, which makes sense. I think when a lower court sees a sentence like that in the U.S. reports, much like in the Royal Canin case, which presented a very similar scenario, the courts will often go along with it. That's essentially what happened here. But I think that, this court has, the authority to check, as it did in Royal Canin, whether that one sentence really establishes a holding. And I think it just doesn't when you look at the posture of that case as compared to this one. Finally, in terms of the practical effects that respondents identify, I don't think that they're that significant. I mean, what happens is after there's an arbitration award, you go to the federal court, and if a party says, look, we're planning to go to state court to confirm the award or vacate it, the federal court can say, look, okay, I'll wait to see whether or not the case ever comes back, and I'll just delay the dismissal a little bit longer. And they'll go to state court and litigate there. I mean, parallel federal and state litigation happens every day in our system in our federal system, and I don't think that the practical concerns here are any greater than they would be in any other case when you have parallel litigation across the federal and state systems. If there's no further questions, we'd ask the court to reverse the judgment below.
Thank you, counsel. The case is submitted.